Welcome to JC 102 Copyright in the Classroom. This course will get you familiar with the intricacies of copyright law, fair use, and other aspects of intellectual property rights. First, a disclaimer. We're not lawyers. The information in this document is not intended to replace advice received from legal counsel. So when in doubt, you should ask a lawyer if you're really getting into the weeds on this. Article 1, Section 8 of the Constitution provides for copyright law, and this is part of Article 1 because it provides for free enterprise by ensuring that people retain their rights to the things that they create and encouraging people to create things. Section 8 deals specifically with commerce, to protect commerce. Creators have a right to prosper from their works. Without this, creators would create, but they would be less likely to share their creations widely because they would always be worried that someone else would benefit from those. Copyright is a positive right, so it's your right to benefit from the things that you create. So what is protected by copyright? In 1790, when this was created, we're just talking about books, literature, maps, charts, diaries, pamphlets, anything that was written down. This has, of course, since 1790 expanded through subsequent laws to include music, movies, photographs, software programs, and most recently an attempt to copyright fashion designs through the Innovative Design Protection Act of 2012 that has not yet become law. In 1990, architecture was also added to this. So if you're just seeing shower in the morning, that is not covered by copyright. Unless, of course, you were to record that and then post it online or sell it on a CD. Things are not copyrighted until you write them down or record them. What is not protected by copyright? Namely ideas and facts. So you can't copyright happiness, date, a statistic, or anything like that. Works within the public domain, which means that they were created after 1923. Copyright expires after a certain period of time. And also familiar designs cannot be copyrighted. So you can't copyright a clover leaf, the equal sign, numbers, letters, anything like that. And you also can't copyright processes or systems. So that would be like a system of bookkeeping, for instance. And the federal government works, and you can't copyright federal government works. So that would be part of this presentation even that was prepared by the Copyright Office. The official copyright notice cannot be copyrighted. And states can have their own laws that differ within this context. And then, of course, unfixed works. So, you know, if you think you invented binary coding and you just sort of talked about it to someone, that doesn't count. You would have had to have written that down somewhere or recorded that you came up with the idea. Copyright extends these 6 exclusive rights to the copyright holder. It's reproduction, preparation of derivative works, distribution of works to the public, public performance, public display, and then public performance via digital audio transmission or video transmission. And then, of course, there needs to be a balance between exclusive rights of the copyright holder and fair use. So the granting of exclusive rights is supposed to encourage commerce, but then you also need to provide for fair use so other people can benefit from the copyrighted idea while still acknowledging that they are indebted to the copyrightor. There are some exceptions to copyright law. One is for libraries because of the unique benefit that libraries provide by preserving documents. And there's also the first sale doctrine, which allows places like used bookstores to sell books that have already been sold elsewhere. First sale doctrine does not apply to electronic files. Does not apply to electronic files yet. This is still being worked out in court. Then there's fair use. So while this provision gives much latitude to teachers and scholars, it's not a blank check to just do whatever you want with the works of other people. There are several guidelines, and part of what makes them specific is how the courts have interpreted laws in the past, not necessarily our individual interpretations and applications of those laws. So fair use in this sense is not the idea that it is unfair that materials have a monetary expense, something that can, of course, sometimes be prohibitive. when we're thinking about what students can afford, or if we're thinking about how long it's going to take us to secure permission from the holders of the copyright. So what you're doing when you are considering fair use is you are thinking essentially what your legal defense would be for using said object. This means that fair use is a defense. It is not a right. Under Section 107, we as educators at a nonprofit institution have the right to criticize, quote, parody, and use in the classroom these copyrighted works. So we have to consider what is fair. Is fair use? The factors that you have to think about are the purpose and character of the use, including whether such use is of commercial nature or is for nonprofit educational purposes. You also have to think about the nature of the copyrighted work, the amount and sustainability of the portion used in relation to the copyrighted work as a whole, and the effect of that use upon a potential market for the value of the copyrighted work. So the purpose and characters that are permissible are not restricted to the list in the preamble you saw earlier. Works copied for educational, nonprofit, or personal use are more likely to fall within fair use than works copied for profit. Transformative uses fall within fair use. This includes parodies, criticism, and commentary on a particular work. You have to think about, does what you're doing add something new, further the purpose? Is it of a different character than the copyrighted item, or does it alter it with new expression, meaning, or message? If you're thinking about copying something for commercial purposes, the bar to use it is much higher than that of fair use, but it's not completely insurmountable. Likewise, you have to think that just because you are using it within the context of a nonprofit does not necessarily mean that you can use it. Then you have to think about the nature of the copyrighted work. The original intent of copyright is to promote commerce, and the exceptions to copyright can't thwart this original purpose. So works more likely to be subject to fair use include factual and clearly nonfiction works, published works, and works important to favored educational objectives. Works less likely to be made fair use include highly creative works. So this is art, music, novels, film, plays, unpublished work even, although it would still have to be recorded in some way. So amount and sustainability are measured both quantitatively and qualitatively. So in terms of quantity, the smallest amount possible for your purpose is what you should use. In terms of quality, sustainability is the part of the work that is most essential. It's what they call the heart of the work. So no matter how small that is, you really should not be reproducing that. But sometimes you can even use the entire work if it's short enough, if it's a poem, for instance. You just have to be using it within a very specific context. The effective use on the potential market is probably the most crucial factor to think about. The courts won't take your lone perspective and motivations into account. What they look at is the effect of widespread conduct, like whatever your reproduction is. So for instance, if you are sampling, if you're a music artist and you're sampling a particular artist's work and the type of music you make is significantly different than the type of music you're sampling, you can generally get away with that. But you can't sample a piece of music and use it in the same music market. And then finally, potential doesn't mean theoretically a market that the holder could enter if they wanted. It means a market that the creator of the original work could logically enter, given the other work they have produced. There's a difference between public domain, in quotes, and the domain of the public. The domain of the public is stuff that's out there and it's known. Public domain, of course, has a specific legal meaning. Just because you can find something on the internet does not mean you can use it in your class or for your own purposes without considering copyright. So the big takeaway here is that public domain is complicated. Someone makes a work available to the public. They can, of course, stipulate that that particular work is public domain, but that's the choice of the creator. That, of course, doesn't mean that someone can't come along and take that public domain work and then create a commercial application of that work, because then the commercial application could actually be copyrighted. So a good example of this would be the work of Jane Austen. The novels at this point are old enough that they are in the public domain, but anytime Hugh Grant wants to star in a Jane Austen movie, those would of course be copyrighted because they have been made more recently. Interestingly, for works that have multiple creators, the copyright is based on the oldest living creator, and that would of course be available for a certain number of years after that author artist's death. And of course this changes a little bit based on the time frame, and you can see up here there are various time frames. So to simplify it a little bit, public domain would be anything before 1923, or published between 1923 and 1963 with copyright notice that has not been renewed, or between 1923 and 1977 with no copyright notice. And then of course there's a period between the 70s and 80s that something is available for public domain because it has no copyright notice and was not registered. And then of course there's also the possibility that the owner could have given up the copyrights willingly. Here are some examples of works in the public domain, which include state and local government documents, but they can of course choose to copyright those. Federal documents are mostly in the public domain, but may not be if they were created in part by a non-government entity. So that would be work for hire, or if someone adds something to it. Foreign works are covered by international treaties, but not copyright. Public domain material cannot be recopyrighted, but derivative works can be, and that's the Jane Austen example we were talking about earlier. So a good rule of thumb is to assume that something has copyright unless you can prove that it doesn't. This gets us to some of the other various applications of copyright. So this takes us to the Teach Act. The Teach Act is different than fair use. The Teach Act gives you more latitude in terms of what you can use as an instructor, but it also requires you to do more work to get permission from the copyright holder. Fair use doesn't require as much from the instructor, but it also leaves you more vulnerable to lawsuits. And so what you're wanting to do with the Teach Act, this would generally apply to something you might post on Blackboard for your class. You cannot replace a textbook. And what you're generally doing is you're providing timely supplemental materials for short periods of time. So if you see an article in the New York Times that you want your students to read, you can of course post that to Blackboard. But if you want to have that same article up year after year, you would have to secure copyright for that from the author or the publication. And this is the reasonable and limited use that's mentioned at the bottom. And you can use objects on Blackboard because Blackboard is a self-contained environment, and that automatically meets the requirement of the Teach Act to limit access to only a few people. And those would of course be your enrolled students. And then with this work, you need to have a copyright notice somewhere in your course that tells students that they cannot take what you've put up there and give it to other people or reproduce it in other ways. And this takes us to another type of use policy called Creative Commons. And you may recognize this from Wikipedia, and you can of course search by Creative Commons licenses. And what Creative Commons is essentially trying to do is it's trying to pick and choose which protections of copyright that the particular creator of the work wants. And as you can see, there's various individual considerations mixed with various liberalities that you're providing. So the license is to some extent defined by the creator at the time of publication. As the Creative Commons website puts it, they let you change your license from all rights reserved to some rights reserved. You can find more information about this at the LibGuide on our website. So if you do want to use a large portion of a work and you want to obtain permissions, there are various ways to do that. Here's some of the places you can go. And here are some legal alternatives for print, images, video, and music, where you can get public domain images, or you can get images for which the copyright has been relinquished. And in the PowerPoint, which is available through Blackboard, you can find some links here in order to evaluate fair use or to find further information on copyright. And in the spirit of copyright, here are our sources. So thanks for taking JC 102, and if you have any questions about copyright, please direct your inquiries to a librarian at the Jefferson College Library. Thank you.